good in the back? Good in the back? All right, good afternoon. My name is Ryan Fong. I'm a Florida Bar licensed attorney specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature, and while formal rules of evidence do not apply, fundamental due process will be observed. Everyone with a case today will have the opportunity to present testimony, and you may also present evidence or call witnesses to testify on your behalf. Please note there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded, and all testimony will be given under oath. The city will present its case first. Information may be displayed on the screens, and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are objections. After all evidence and testimony has been presented, I will make a ruling, and my ruling will be reduced to writing and mailed to you. At this time, I will swear in all witnesses. So if you intend to testify for your case, please stand and raise your right hand. Okay. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Okay, thank you. You may be seated, so we'll work through the agenda here. First order is to approve the minutes of the May 12th meeting. I've reviewed the minutes and will approve them as presented. So we're going to move to the first case, which is the request to reschedule an appeals hearing.
Yes, sir. On May the 27th, Mr. Bass has contacted the city attorney's office and requested we move his previously scheduled hearing from July 14th, 2025, with some difficulties receiving some information he's needed for his case, and would like it postponed until October 13th, 2025 at 12 noon.
Okay, at 12 o'clock noon.
Mr. Bass is present if you had any questions.
Okay. Ms. Bass, do you have any questions on that? No? Does the city have any objections to that date at all? No? Okay, I'm going to go ahead and approve that and have the rescheduled hearing set for October 13th, 2025 at 12 p.m.
Thank you, sir.
Thank you. Okay, the next case I will call is case 2523 C Cube Strip LLC.
So I have 3 exhibits to submit. The first one is the affidavit and notice of hearing for today's hearing. The second is a copy of the orders from the March 10th hearing, and then the third is a cost recovery statement.
Thank you. Okay, you can proceed.
Okay. So again, this is the Massey hearing for case number 25-23. Our respondents are C Cube Strip LLC, Tuan Lee being the registered agent. The violation address is 5155 South Washington Avenue, the Commons area. We have 3 mailing addresses, and our code violation is from the International Property Maintenance Code, subsection 505.3 for water supply. So the posting for today's hearing was completed on May 21st, posted at City Hall and at the property where the violation exists. Certified mail was sent on May 6th, 2025. All 3 were returned either unclaimed or unclaimed because they were vacant. So our summary, the case was originally heard March 10, 2025. Tuan Lee, the registered agent, was present and provided testimony. The respondent was found to be in violation and ordered to correct the violations on or before noon of May 9th. 2025. And if compliance was not achieved, a fine in the amount of $100 per day commencing on May 10th, and to continue daily until the violation was corrected. Administrative costs in the amount of $234.19 were imposed. On May 8, 2025, I did meet with Mr. Lee at the property. He did state that he was dealing with FP&L with his claim for the damages to the sidewalk, water line, and retention pond, and that he was waiting to start any of those repairs until the claim was processed. I did an inspection Friday and as well as this morning. There's been no action taken or permits issued to correct the violation.
Okay, thank you so much. Okay, all right, so I find based on the evidence and testimony presented that notice was properly provided to the respondent and the respondent did not appear today. The evidence demonstrates that the property located at 5155 South Washington Avenue remains in violation and no repairs or corrections been made. The property is not in compliance with the previous order dated, what was it, March 14th? March 10th, 2025. And therefore, I find that the city has established continuing violations of Section 505.3 for water supply. And accordingly, a fine of $100 per day is imposed commencing on May 11th, then, right? May 10th,
May
excuse
10th.
me. And continuing daily until the violations are corrected, and the cost of $234.19 has not been paid and is due and owing. A certified copy of this order will be recorded in the public records constituting a lien on the property, and the respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. It is so ordered. Thank you.
Thank you, sir.
The next case is 25-30 Vermont LLC.
Great. I have two exhibits for you. One is the notice of hearing posting and the cost recovery affidavit.
Thank you. You can proceed.
In this case, 2530 Vermont LLC, location of 1091 South DeLeon Avenue, and then the mail to address is 2582 McGuire Road in Ocoee. Multiple violations on this property. You want me to read them all?
No need.
This case was originally heard on March 10th, 2025. The respondent was not present. The respondent was ordered to correct the violations on or before noon on June 6th. If compliance was not achieved, a fine of $100 per day per violation commencing on June 7th and continuing until the violations are corrected, and administrative costs of $146.14. As of today, an hour ago when I went by, there was no indications that anything has been corrected. I've had no contact with them or the residents of the property. I don't know if you need the pictures or not, but
No need. No.
that's pretty much it. It's, as far as I can tell, the same condition and stuff.
Okay, and no, you said no contact with them?
There's been no contact with anybody, so,
Okay,
and the
Alright.
respondent's not here.
okay, thank you. Therefore, I find based on the evidence and testimony presented that notice was properly provided to the respondents and the respondents did not appear. The evidence demonstrates that the property located at 1091 South De Leon Ave remains in violation and no repairs or corrections have been made, and the property is not in compliance with the previous order dated April 21st, 2025. I find that the city has established a continuing violation of those sections of the IPMC listed in the order dated April 21st, 2025. And accordingly, a fine of $100 per day is imposed commencing on June 7th, 2025, and continuing daily until those violations are corrected. Additionally, the cost of, let's see, where was it?
$146?
$146.14 has not been paid and will also be due and owing. Certified copy of this order will be recorded in the public records constituting a lien on the subject property, and the respondent is required to notify code enforcement once it is brought into compliance so that code enforcement can verify and confirm it is so ordered. Anything further on that case?
No, I think I did make an error. I did say March, but it was April when it had the hearing.
Okay.
Yeah.
I got the order in front of me, so I saw it here.
Yeah, the order's correct.
All right, thank you. I believe the next case is the same respondent. So that case is 2531 Vermont LLC. You can proceed.
Yep, again, I have two exhibits to present to you, the notice of hearing and the cost of recovery.
Thank you. Okay.
And again, Vermont LLC, the violation address of 1545 King Court in Titusville. Mail to address is the same, 2582 McGuire Road. The violation charges, 12 violations in total, and several violations there. This case was originally heard on April. The respondent was not present. The respondent was ordered to correct the violation on or before noon on June 6th. If compliance wasn't achieved, $100 per day per violation on June 7th until the violations have been corrected and the same administrative costs were imposed, $146.14. As of today, there's been no corrective actions taken on the property, and I've had no contact with the respondent or the tenants.
Okay, thank you. Therefore, I find based on the evidence and testimony presented, the notice was properly provided to the respondent and the respondent did not appear. The evidence demonstrates that the property located at 1545 Kings Court remains in violation and no repairs or corrections have been made. And therefore, the property is not in compliance with the previous order dated April 21st, 2025. Therefore, I find the city has established a continuing violation of those sections of the IPMC listed and named in that order dated April 21st, 2025. Accordingly, a fine of $100 per day is imposed commencing on June 7th, 2025, and continuing daily until the violations are corrected. Additionally, the cost of $146.14 has not been paid and is due and owing. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm it is so ordered. Thank you.
Excuse me, sir.
Yes.
If, as you were reading it, if you could add per violation to each of those orders?
Sure. You mean the fine?
Yes, sir,
Fine.
$100 per day per violation,
Yes.
as well as the two prior to that.
Okay, so the cases of 2523, 2530, and 2531
Yes, sir.
will have a fine of $100 per day per violation, and those will be imposed and continuing daily until the violations are corrected. Thank you.
Thank you, sir.
Thank you. Okay. The next case is case 25-32 JL Miami Homes LLC.
Again, this is a Massey hearing. I have two exhibits for you. One is the notice of hearing for today and the cost affidavit of $128.58.
Okay.
All right, and again, like you said, JL Miami Homes, violation address 990 Alfred Street. Mail to address is 3446 Southwest 18th Street in Miami. There were 6 violations on the original case. The initial inspection was back then. I'm sorry. Here we go. This case was originally heard on April 14th. My apologies. I had the same error on that one too, apparently. The respondent was given 2 months, which would have been June 6th, to correct the violation. If compliance was not achieved, a fine of $100 per day per violation commencing on June 7th, 2025, and continuing until the violations are corrected. And the administrative costs of $128.58 were imposed. And when I went by there today, same thing, there's been no corrective action, no permits pulled or anything. And the respondent is not here today.
Okay, thank you. I find based on the evidence and testimony presented that notice was properly provided to the respondent. Respondent did not appear. The evidence demonstrates that the property located at 990 Alfred Street remains in violation and have not been corrected. Therefore, the property is not in compliance with the previous order dated April 21st, 2025. And I find that the city has established a continuing violations of those provisions cited in the order dated April 21st, 2025. Accordingly, I find a fine of $100 per violation per day will be imposed commencing on June 7th, 2025, and continuing daily until the violations are corrected, and the cost of $128.53 has not been paid and is due and owing. Certified copy of this order will be recorded in the public records constituting a lien on the subject property. Respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. It is so ordered. Thank you. All right, the next case is case number 25-33, Robert Kirk and Crystal Kirk Cook.
I have 3 items to submit. The first one is the affidavit and notice for today's hearing. The second is a copy of the previous order, and the third is the cost recovery statement. So once again, this is the Massey hearing for case number 25-33. Our respondents are Robert C. Cook and Crystal Kirk Cook. Our violation and mailing address are 925 Cleveland Street, Titusville, Florida. We had 2 violations set for Massey hearing today. That was the IPMC section 404.4.4 and section 12-23. The other violation for windows and doors has a different compliance date. So our notice of hearing was posted at City Hall and hand-delivered to Mr. Cook on May 21st, 2025. The certified letters were mailed on May 6th and signed for on May 12th of 2025. The case was originally heard on March 10th, 2025. The respondent, Robert Kirk, was present and provided testimony. The respondent was found to be in violation of the stated codes and ordered to correct violations of 404.4.4 and 1223 on or before June 6, 2025. If not achieved, a fine in the amount of $100 per day per violation commencing on June 7th and continuing daily until the violations are corrected. Administrative costs in the amount of $216.58 were imposed. So I did meet with Robert Kirk on Friday, June 6th, and was provided access to the interior of the house and confirmed that the violation of section 404.4.4 was in compliance. The bedroom or the bed in the living room had been removed and the individual staying in the porch was moved to an interior room. The inspection of the exterior of the structure found the trash and debris to remain even though it had been reduced, and so still remains in violation. I have photos. These photos are from the previous presentation. So this is my compliance photo from Friday, showing the bed has been removed. And this is the trash and debris that remains on the property. So I am requesting that the daily fine for the trash and debris be imposed.
Okay. And you've spoken with a respondent, and he's working towards getting, like, most of this done, or was in the process?
They're in the process, it just ebb and flows. It'll be reduced and then more will come, and it's,
I see. Okay. All right, thank you. Okay, I find that based on the evidence and testimony presented, that notice was properly provided to the respondent, and the respondents did not appear. The evidence demonstrates that the property located at 925 Cleveland Street remains in violation, specifically Section 12-23 for trash and debris, and has not been corrected. And the property is not in compliance with the previous order dated April 21st, 2025. And the city has established a continuing violation of Section 12-23 for trash and debris. Sections, what was it? 404.4.4 is now in compliance.
yes.
Okay, so accordingly, a fine of $100 per violation per day is imposed commencing on June 7th, 2025, and continuing until the violations are corrected. And did you say the cost was?
The cost
not
was
paid yet, right?
$216.58.
Okay, and the cost of $216.58 has not been paid and will be due and owing. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. It is so ordered. Thank you.
And just to clarify that the violation of 304.14 will be coming back in front of the magistrate in July.
Yes, I see Section 304.14 did have a different compliance date, so that would be addressed and heard at that date.
Thank you.
Thank you. Case number 25-67, Nicole's Appliances by Danny.
Again, this is a Massey hearing. I have the affidavit of notice of hearing and the cost recovery for $216.58.
Thank you. You can proceed.
This one actually doesn't have a PowerPoint. This one was a business tax receipt.
Oh, okay.
He was given time to, he's never had one, and so it wasn't an expired one. He just hasn't had one. He was given a $200 fine if he didn't correct the violation. And as of today, he hasn't corrected the violation or reached out to obtain a active business tax receipt. So we're just requesting the $200 fine and the administrative costs.
Okay.
The original also included the fees from the business tax receipt owed. This is additional to that.
Do you have that number, or is that in
No, sir.
in order somewhere?
They were unable to factor in just exactly how much that they do owe.
I'm sorry?
They were unable to actually factor in how long he's been in business without one.
Oh, okay.
With that,
Is there-
I believe that the $200 per day would be appropriate in this matter.
Is it a $200 per day fine, or is it a
Yes,
flat
sir.
one-time 200?
Two-
It's per-
200.
Okay, all right. I find based on the evidence and testimony presented that notice was properly provided to the respondent and the respondent did not appear. The evidence demonstrates that the property located at 3304 South Hopkins Ave remains in violation and no corrections have been made. And the property is not in compliance with the previous order dated May 16th, 2025. And therefore, I find the city has established a continuing violation of sections 11-31 for business tax receipts to be in violation. Accordingly, a fine of $200 per day is imposed commencing on June 7th, 2025 and continuing daily until the violations are corrected. The respondent will also be responsible for any fees that were incurred for the business tax receipt once applied if determined at a later date. Additionally, the cost of $216.58 has not been paid and is due and owing. And a certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm the same. It is so ordered. Thank you. Looks like we have one more hearing on the agenda, case 25-61, Elizabeth Olson. Are you Miss Olson?
No.
No? Okay. Okay, go ahead.
I have 3 items to present to you: the notice of hearing, a notice of violation affidavit, and the cost recovery.
Okay, you can proceed.
Was the respondent Elizabeth Olson, violation address 2767 Pine Ridge Drive, mail to address is the same. The violation is section 1223, junk and debris. The initial inspection was on March 4th, 2025. The date given to comply was March 25th. Notice of respondent was mailed first class and certified on March 5th. And the notice of hearing on May 19th was posted at City Hall and on the property, and it was mailed certified and first class on May 7th for the hearing. This was basically, I received a complaint from a neighbor about junk and debris being stored on the side of the house. I observed miscellaneous debris and items on the side of the house. Basically, this narrative has changed as of today. I've spoken with her. As of today, the property has been brought into compliance. This is the original pictures back in.
It has been brought?
It has been, but I'll
Okay.
explain it in a minute. Sorry. I just want to show you the debris pictures and stuff and what it looks. This is what it looked like when we did the inspections. Some of the items would go, some of the items would come back. This vehicle showed up with this trailer. It kept coming and going until last week. They started cleaning it up finally because of the hearing notice. And as to today, when I went by, there is no violation on the property. All that junk and debris is gone. The vehicle's there, it's backed in, but it's not causing any issues or anything, but everything else is taken care of. We were originally just trying to order the respondent to correct the violations, what they did, and with the cost affidavit, but as of today, it's been complied, brought into compliance. We're pretty much just requesting a finding of fact that it was in violation, so if it does become a repeat violator.
Okay. Thank you.
Costs? Costs or no?
This is an initial hearing. Finding of fact, not costs.
So it's just finding the fact, not the cost.
Okay, so you guys are,
Yeah, just finding a fact, no cost at this time.
okay.
Constitute a repeat violation.
Okay, all right. All right, thank you. So I've accepted and considered the documentary evidence, including photos and sworn testimony related to this matter from city staff. I find that the respondent, Elizabeth Olson, is the owner of the property with the address of 2767 Pine Ridge Drive. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this meeting. Based on the evidence presented, I find that violations of Section 12-23 of the City Code, which is junk and debris, did exist upon the property, and respondents has corrected that as of the date of this hearing. And so I find that let's see. Any further and future violations of the same section shall be classified as a repeat violation, and a certified order may be recorded in the public records of Brevard County. It is so ordered.
Thank you.
Anything further? I think that's it.
The only thing I have is, again, thank you for all you've done for the city of Titusville while being as one of our magistrates, and wish you the best in the city of Ocala.
Yeah, thank you. It's been a pleasure. Thank you for having me. I'm going to go ahead and, let's see, is there a code enforcement manager's report that we need to go over or anything?
That was my report.
Okay. That's a great report.
Ms. Farrell may have something under her.
Nope. All right. Thank you, guys. So I'm going to go ahead and adjourn this meeting.